everybody. Happy Friday. We're back to the fall schedule. We're back to 4 o'clock. So it's good to see everybody. Thanks for coming. It feels like we're heading into summer again, but it's actually we're heading into fall, but it's been nice and warm. Right now, just so everyone knows, we're getting like a funky lightning downpour right now. So if we get bounced out, I may not be able to get back in. But let's hope everything stays stable and we're able to go through with the little webinar here. But again, thanks for coming. Hopefully we'll be okay. So the usual thing, right? These webinars are provided for general, informational, and discussion purposes only. These webinars do not and cannot form an attorney-client relationship. Everyone knows that the information exchange does not constitute legal advice. I know this is a sensitive topic today, so I'm going to say this again. The information exchange does not constitute legal advice. To obtain legal advice, you must contact an attorney directly, including me, enter into a written retainer agreement, and present your particular facts, not just general facts that we may be talking about today. No information discussed during these webinars will be kept confidential. So be careful what you say. Because we will not be keeping these confidential, even though today is a discussion about transparency and confidentiality. So that being said, the dogs, where have the dogs been? My gosh, we're getting no dogs. But today we have two cats. These are Cheryl Palant's cats. Hi, Cheryl. We've worked with Cheryl for many years now over at Renaissance Raritan Valley and other associations too as well, I think, Cheryl, right? And let's see, the one on top of the copier, yeah, that's I guess Sophie, and I guess she also calls this one Crash, and then there's also this long French name that I really can't pronounce. Sorry, Cheryl, if you're out there, I don't see you, but I can't pronounce the French name. Madeline, you speak French, right? There you go. Yeah, Madeline speaks French. Cheryl, I guess, does too. And this is Brat. The short version is Brat, and I'm going to leave it at that. Beautiful cats, though, Cheryl. Thanks so much for sending them in. And Madeline can translate the French if we have to. So that was a dog and cat of the day. And now the first topic is transparency. So transparency, for those of you who know me and have known me a long time, I am a huge advocate for transparency with respect to boards, transparency with respect to business that associations do, and transparency with respect to other boards outside of the association world. And for those of you who know particulars about me, you'll know that I litigated the Open Public Meetings Act all the way to the New Jersey Supreme Court before I embarrassed myself in front of the Supreme Court and got a good spanking from the justices, and probably I deserved it. But you know, that's what happens. You live and learn. So I am a big advocate of transparency. And why transparency? So transparency is required under various laws that impact the association. Most of you know those laws. You deal with the Condo Act, the Plan Real Estate Development Full Disclosure Act, and related regulations, etc. And as we got into the Radburn laws and regulations, you also know that the administrative regulations really started focusing more and more on transparency, which is great because of those of you who do know the background of Radburn. It was a closed board, a closed society, if you will, at the board level, and the residents were basically just shut out. The membership was shut out of association governance and ability to run for the board. So it's a good thing. So transparency is a good thing. It is required. Why did I title today's seminar The Tension Between Transparency and Confidentiality? Because even though transparency is required, association boards and administrations still need to function. They still need to function, and they need to function at times with confidentiality. Why? Well, for a number of reasons, the law actually specifies that. So even though the regulations relate to transparency and focus on transparency, and I'll share a screen in a second just so that you can see the reg itself. The reg does provide, even though it's a little silly, the reg is a little silly, I'll admit that, and sometimes the DCA kind of, trips over itself. Oh, hey, Gene, I haven't seen you in a while. Even though the DCA sometimes trips over itself, the DCA expressly in the regulations listed exceptions to the transparency. So I will requirements. I will show you this in 1 second. All right, so there's the reg coming up there, and this is Exhibit 3B from Wendell Smith's and Christine Lee and Dennis Estes' book, the GAN book, published by GAN. Great book. It's also available on in electronic format on the internet. So the executive board may exclude attendance of association members and voting eligible attendance at meetings or portions of meetings where, right, the exclusion shall only apply for discussion of any matters listed in this paragraph. Okay, so those in which the disclosure would constitute an unwarranted invasion of individual privacy. Where do we see that the most? And many of you have heard this before. Where do we see that the most? Requests for handicap accommodations. That's a big one. Somebody has MS, somebody has a child who has a difficulty or a disability, or a member or a resident has another disability. The association is not going to talk about the member's disease or disability in an open session meeting, which makes a lot of sense, right? The other place that we see that is inherently private is someone is not paying, right? Someone's not paying. We don't get in front of the membership and say, Bob's not paying, right? No, we don't do that. And there's a caveat to that, and we'll talk about it in a second. So that's invasion of individual privacy. Like I said, the most common are requests for handicap accommodations and collection issues. Pending or anticipated litigation or contract negotiations. Those words, and I emphasize them that way because those words are important. Pending litigation. So somebody sues you, meaning the association or the board members, and the association certainly is not going to talk about that in an open session, right? Because if they do, the people in the audience may be parties to the litigation, and they're going to be sitting there taking down notes all about the litigation strategy and everything you're talking about. So they would be, thank you very much. Thank you for talking about the litigation. I understand your tactics now. I understand how much you're going to spend, how you're going to deal with the litigation, et cetera. So that would be foolish, right? And the DCA gets that. What about anticipated litigation? What does that mean? When do you anticipate litigation? Generally speaking, when you have anticipated litigation, and everyone has seen these emails, the email to the association's board, whether it's from a member, a volunteer, another board member sometimes, or an employee, or even a neighbor that says, hey, if you don't do X, I'm going to sue you, right? That's the most obvious. But it doesn't need to be, I don't think, an express written threat. It can just be a situation where somebody, for example, says, I'm alerting you to the fact that there's a problem, right? So, for example, we see many, especially in our adult communities, trip and fall cases where somebody reports an incident where there was a trip and fall. And generally speaking, even though there's no threat that anyone is going to sue the association because of the trip and fall, the association at the next open meeting is not going to say, hi, everyone, we just want to let you know that Bobby tripped and fell and broke his hip, and we're really concerned that he could sue us. Okay, so generally speaking, that would be anticipated litigation. That doesn't mean that litigation is actually going to happen. What about contract negotiations? This does not mean the contract itself. It's contract negotiation. So the association goes out to bid with the specification, 3 or 4 bids come in, and the board is discussing them in closed session. The discussion in closed session says, bidder A, B, and C, these are the prices, these are the specs. Are they really bidding apples to apples? Generally speaking, bidders do not. So many times the board and management have to work the proposals back to a point where you get them to apples proposals. Otherwise, you're never going to really get a good handle on the dollars and cents of what's being put in front of the board. So contract negotiations, we want vendor A to go back and adjust their bid because something looks like it was left out. We want to go to the vendors and say, hey, listen, all the numbers came in, but they all seem funky, way too high. Maybe our proposal, our RFP was not clear, but this is what we were really looking for, right? So those contract negotiations would not be open. Those involving employment, promotion, discipline, or dismissal from a specific employee or officer of the association, right? So this is generally employment type stuff. Obviously, disciplining, termination, firing, perhaps removal, would generally be discussed in a closed session meeting, and those falling within the attorney-client privilege. And this is important, to the extent that confidentiality is required in order for the attorney to exercise his or her ethical duties as a lawyer. So Mike, as you know, Mike and I are here, are lawyers. Heather's here. I think there's a couple other of our attorneys online with us too. Some associations misunderstand this section. They believe, wrongly sometimes, that if an attorney is in the room with them, that makes the entire meeting confidential, right? And I've gotten people say, well, Fran, you were there, so we don't have to disclose anything. No. So the provision with respect to issues falling within the attorney-client privilege are when, even in a Zoom, the attorney is talking to the board members and communicating back and forth regarding the legal issue. If the meeting then goes on to discuss things that have nothing to do with attorney's advice or with the attorney, but the attorney's still there, that would not be subject to the attorney-client privilege, right? It's make sure that you don't think just because an attorney is sitting in the closed session that it's all subject to the attorney-client privilege and is excluded with respect to that. This is where now the next section, section 2, is where the DCA got a little silly. A vote taken at a closed meeting shall not be binding. If the matter requires a binding vote, it shall be taken at a subsequent open meeting in a manner that does not disclose any confidences. Right? This is how you know the DCA does not sit in the shoes of most of you as board members, managers, committee members, association volunteers, right? So prior to this reg going into effect, the association was permitted to vote on those topics above, those 4 topics, 5 topics, in closed session, in executive session, and the votes will be binding. This regulation, though, says a vote taken at a closed meeting shall not be binding. So the question is, how do you implement that? I, Fran McGovern, hereby make a motion to fire somebody. Do we have a second? Mike, do we have a second? Yes, we do. Mike has a second. All in favor? Everybody. Great. I, Fran McGovern, make a motion that we discipline somebody by docking his pay for not showing up. Oh, sorry, I shouldn't say his, because it might reveal who it was. So I make a motion that we discipline somebody for something, right? I mean, it's a little silly in the real world. Like, how do you do that? I make a motion that we direct our lawyer, Fran McGovern, to file something about something, right? We are going to institute something. All in favor? Right? So it really, I understand, I think the DCA's heart is in the right place, but from a practical standpoint, makes things very, very difficult. I make a motion that we are going to assign a parking spot to somebody for some reason. Because you can imagine being at that meeting, everyone out after that meeting is going to walk up to the DS and say, what just happened? And why is somebody who we don't even know getting an assigned parking spot for the reason we don't know anything about? Right. So it's going to, I think it's very, very odd. I think the DCA went a little too far with that. But like I said, I think the DCA's heart was in the right place, but they went a little too far. And as many of you probably know, there is litigation pending to try and change these regulations. However, the DCA has not been super duper receptive to the Community Associations Institute's suggestions with respect to these regulations. It seems like more often than not, they said, hey, thanks so much for the comments, and we are moving forward. Thank you. Right? Have a nice day. So that's not the end of story, though, with transparency and confidentiality, right? So that's meetings. That's kind of the meeting part. And judges and all of us kind of look to that as some guidance. And as most of you know, that the associations, and it's specifically stated in the Condo Act, that that residents are entitled to inspect the books and records, right? To look at the association, they inspect the association's accounting books and records, right? How far does that go? How far does that go? We don't always know how far it goes. It is true that the books and records generally pertain to the financial books and records. So that would generally be your ledgers, your bank account statements, perhaps the invoices that come in, things like that. And also other things. So you may see contracts themselves, right? Because the contracts generally have to back up the expenditures. The invoices have to back up the expenditures. It doesn't say this actually in the act itself, but generally speaking, you would have the ability to look at the association's audits, right? So that all makes sense. And I'm in favor of erring on the side of providing access and inspection to the association's books and records, and even, interpreting that liberally. How far do you go, though? And there is a line. The association's board, I think, has to wrestle with that in terms of how far. There are many times that we see transparency access provided in the law weaponized. And when I say weaponized, what I see, and the DCA actually speaks against this in the comments to the regs, we get a request to inspect all of the association's books and records from 1987 to date. Really? Really? We are going to inspect the association's books and records from 1987 to date? And I've actually had that request. So how we try to deal with a request from like that is work with the member, but also try to tailor the request and pare it down to a point where we can say, okay, listen, what are you looking for? Let's narrow it. And they say, well, I'm really focusing on the landscaping issue. Okay, let's do this. We're in landscaping for 2023. Let's start there, and then we can work our way backwards. And then if you find something that'll help guide you through the process. The kind of the unaddressed part of confidentiality is many associations, boards have confidentiality agreements for board members and committee members. Are board members compelled to sign a confidentiality agreement for eligibility for the board? No is the answer. No is the answer. However, you are still bound to confidentiality as a board member. I have had board members who have said to me, no, I will never sign a confidentiality agreement. And I say, that's nice. Here you go. Here's a copy of the confidentiality agreement. I can't compel you to sign it. However, you should be reminded that you are still obliged, pursuant to your fiduciary duty, to maintain confidentiality of the board's business. Whether you sign a confidentiality agreement doesn't matter. You are still bound. Your fiduciary duty already binds you. Okay, so that's an issue that comes up a lot of times with board members. So you can't, and some people, I get this phone call sometimes, we're going to throw him off the board because he refused to sign the confidentiality agreement. No, you're not. No, you're not. Okay, but again, I would still give that person the confidentiality agreement or provisions just to remind them. One thing that the boards have to be aware of too is that more often than not, confidentiality agreements and confidentiality provisions can be what I would call overbroad, in the sense that they cover things that aren't confidential, right? So if you are in an executive session meeting and you're talking about one of those topics, somebody's, handicap accommodation, and then you're talking about something else about employment and hiring, firing people and stuff. And then during the meeting itself, someone starts talking about, I'm thinking maybe we should change the color of the shutters from blue to dark blue, right? And especially if that's out in the community, it can't be a gotcha moment. You breached confidentiality. You should never have told anyone that we were thinking about changing the color, the shade of blue from navy blue to sky blue, right? Especially if it's out in the community. There may be a reason for that information to be confidential, right? At that time, we don't know. This is what I would say how boards should handle that. If there's a reason for the board to say that topic is confidential, The board should explain that to the board members who are present or committee members, explain why, and actually highlight to them that this is to be kept confidential. Why in the world would shutter colors be something that would be kept confidential? I don't know, but there may be a reason. Maybe the association is trying to figure out bids requests. Maybe the association is trying to understand how much money it would cost in the preliminary discussions, and the association is just not there yet. Even though the association were to come to that conclusion at a board meeting, hey, everyone, you must keep the shutter color thing confidential, there are even exceptions to that. And here are some of the exceptions. If the information is publicly known already and available information through somewhere else, it's not confidential, right? Everyone in the community knows it. It's all out there, and we're talking about shutters and blue and navy blue and sky blue and robin's egg blue, blah, blah, blah. And it's all out there. Well, you can't breach confidentiality if the information is already public knowledge, public information, right? So if that makes sense to everyone, I hope it does. Non-confidential information shared by someone else besides the disclosing party. So if a third party comes to somebody and says, hey, I want to let you know, I heard this, right? And the person goes, wow, that's interesting. That person hasn't disclosed anything, right? Somebody else has told it to them, even if it's not common knowledge throughout the community, right? Information that can be shared with permission of the disclosing party. So if the board says, normally this information will be confidential, and this happens to us a lot in transition. We're talking about a transition litigation, and we think it's going to cost a lot of money. And the board is saying, well, golly, I don't know. We're really going to need membership support. And probably many of you on this call, if you've seen me go through construction defect transition, you would see me stand in front of the association and actually say to the membership, we think this transition is going to be very complicated. The association is suing for $20 million. We think the case is going to take 6 years, right? It's going to take 6 years, and it's probably going to cost the association about $2.5 million in attorney fees and probably about $600,000 to $700,000 in engineering fees. Well, no, that's not confidential, right? That's not confidential because it's been out there. The board, if you will, through counsel or through the engineers, has put that information out there, right? So you can't say, well, that was part of a pending litigation and the attorney was talking, therefore you breached confidentiality. No. Information independently developed by a receiving party. So, and this rarely happens, but it happens sometimes. Generally speaking, management is the one who goes out to bid, right? And they go out and they find bids and so forth and so on. There are occasions, though, rarely, but rare, it happens, where one of the board members goes out and says, my cousin Larry does snow removal. Larry's awesome. I'm going to go out there and get a bid from Larry. And she goes and gets a bid from Larry. And Larry says, I'll do all your snow removal for $3,500, right? Well, she has knowledge of that. She generated that herself, right? So that's not going to be confidential, at least the Larry bid. That doesn't mean all the other bids are going to be waived. Information that the receiving party must share because of a lawsuit, right? So everyone knows that even though we have all kinds of crazy confidentiality agreements and various other things, that when a judge gets involved and she or he says, Fran McGovern, produce that item, unless I respond with the judge saying, I need a protective order, judge, it's for a special reason. And in that case, if we file a motion for a protective order, generally what happens is she or he says, Fran, you know what? Come on down to the courthouse. We're going to go in the back room. You're going to show us, me, the judge, and the other lawyers the stuff. We're going to do perhaps an in-camera review, and you're going to decide, the judge is going to make a decision whether or not that's going to be released, okay? So it's not that just somebody during a litigation says, hey, you got to produce it. It can't be produced until the court says it has to be produced. Nevertheless, a legal exception exists if a court directs somebody to produce the confidential information. I have a question. One second. So I have a question that is a particular question. So let's see. Eric Norbaum sent this in. Thanks, Eric. Wherever I can't see him, he's out there somewhere. Eric. He says, "Hey, we've recently had residents asked to see our reserve study, specifically asking for electronic copy or have it posted to our website, and for specific projects to view our engineering study and contract with a vendor. Can you discuss if requests like this are okay to share, or if there is anything the board should consider before sharing?" So there's nothing in the acts that say the association must um, produce its reserve study. I mean, generally speaking, it's not part of its financial books and records. However, my interpretation of books and records is somewhat broader than I would say most courts. So if, and this is not advice to anybody, we're just talking, I would generally say that the association is free to produce its reserve study. And generally speaking, I believe it's a good thing to do because the reserve study should, doesn't always, translate into your budget, right? So the reserve study generally would translate into your reserve and deferred maintenance budgeting, so that if you saw that the clubhouse roof, for example, has a 25-year useful life, but the engineer has said there's only 10 years left on that useful life, somebody who was a member would say, well, wait a second, guys, there's only 10 years left on the roof of the clubhouse in terms of useful life. And in the line item for a clubhouse roof, it says zero balance for reserves. What's the problem? Right. So I think there's a very good argument that that should be made available with respect to financials. I'm not so sure that a judge would make you produce it, but I think it's a pretty good a thing to disclose, especially if you're educating your members on it. One thing to keep in mind, and many of you know this already, members also often look at reserves and surplus as the same thing. You know that is 100% wrong, right? Reserves are earmarked money. It's not just extra money you have laying around, right? Because people in your membership who aren't involved in the board and committees will say, well, can't we just use the reserves? We got reserve money laying around. No, those reserves, as you know, are earmarked. So the question goes on to say they specifically ask for electronic copy or to have it posted to the website. That's really a call for the board in terms of whether you want to give them a hard copy. The statute basically says you have to let them come in and inspect it. The regs basically say, hey, you also have to let them copy it. But there's nothing that says you must give them an electronic copy, you must post it to the website or anything like that. I like the easier, the better. So a lot of boards are uncomfortable with this. I like posting financial documents to the website as long as it's behind a member page, right? Where you have a member password page, so it's not on the regular membership. Some boards are uncomfortable with that. But again, I lean towards the transparency side. And I think it makes it a little bit easier for the association and especially the manager when someone says, hey, Fran, I want to see the budget. It's not like you got to go put the person hard copy of the budget out in the thing. You could just say, go to your membership page from the association's website and click under financial information. They click on there and there's the budget. That's awesome. And I would say the same thing with minutes. I love that stuff, financial statements. Maybe I'm just a nudge, right? Maybe I'm just a nudge. I like to look at that stuff, right? I like to look at it. I like to see it. Maybe it puts me to sleep, but I like to see that stuff. What about for this? Yeah, yeah, go ahead.
Just maybe you want to comment on this. This comes up fairly often when a potential purchaser contacts the property management company and says, hey, listen, we have someone that wants to buy here, but we want to see your financials first. You want to just touch on what you think the management should do or the board?
Yeah, so I think the answer is you need to request them through your seller, right? I mean, I think that's the cleanest way to do it. Most associations, and Mike, you can add to this too, that I see, that's how they respond. They say, we're all for it, but it's really a seller issue. The seller is the member is entitled to all that, and you should get it through your seller. Make sense, Mike?
Agree. Yeah.
Yeah. So it's an issue that comes up regularly. One thing I've seen recently is, I want complete copies of the association's insurance policies. Is that a financial book and record? I think not. But maybe. I mean, it goes to securing especially with respect to property coverage, the association's assets, and with respect to liability coverage, it deals with, you know, protecting the association with respect to claims. So arguably it is. I would generally say that insurance policies, I are on the side of transparency, but some boards really find that offensive, and some parties would disagree vehemently with me on that. But it really just depends. Let's see. So we had a couple questions too. Robert Thomas, thank God, Robert, you're sending me a dog picture. Where are you? Yeah, send that dog picture over. I cannot believe the dog people have been selling me out. Jackie, if you're out there, it did not come through. I can't see Jackie's question. How about Alex? What about requiring a board member to sign a code of conduct that includes wording that includes some level of confidentiality? You know, so Alex, the problem with signing a code of conduct, again, is under the regs, you can't mandate that, right? You can't mandate someone, you must sign this or you are not eligible to run for the board. That's just not true, right? People can run for the board, people can get on the board. But again, it will be a reminder. I don't think it's a bad thing. And you can remove somebody from the board if they're threatening people. You know, it can be good cause for removing someone from the board if they don't behave properly. But at the same time, I don't think you can compel people to sign various agreements. Like you would, you know, many of you have been involved in business your whole life, and you see it's standard practice to have people sign an NDA in business, and the NDA says, I will not disclose the following, blah, 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 blah. Or many of you have probably been employees where you've signed the same thing and your employer has said you must do that. Why the DCA is so, I think, against that type of thing is the Radburn case has shown that if the wrong people get the wrong tools in their hands, they will use those tools to exclude people from serving on the board, right? They use it as a pretext for excluding people from the candidate pool, which is not a good thing. Okay, the question from Jackie says, does an association have to accommodate an owner's request to have financial records emailed to them because they won't come to the management office? So, you know, Jackie, I don't think there's anything that mandates, you know, that somebody email books and records. It says come in and inspect. However, I don't think if the association keeps them in electronic format, the regulations, in my opinion, would say that you should send them in electronic format. That's my interpretation. There are people who would disagree with me. If I was a judge, though, and there was a lawsuit and the records were kept in electronic format, and someone came before me and said, you know, I had to sue the association because they said I had to come from where I live in South Carolina and to come up to New Jersey for my summer place to physically inspect the books and records when they had them in electronic format, and they refused to send them to me in South Carolina, I would not be a happy judge, right? So people, I think, get the wrong sense of the association unless there's a really good reason not to send them in electronic format. If the association does not send them, if they're already kept in electronic format, it really, in my opinion, can be read as obstructionism, right? Does that make sense? Obstructionism. Sorry, they can't be sent to you. Now, the DCA does say that associations can charge a reasonable fee associated with sending copies, etc. So I don't know how that will be calculated, but you can do that. I just sent one of my pup to you. Oh, that's great. Linda Patterson sent me one too. Thanks, Linda. Next month. Oh, we got more. All right, we got the dogs on board now. Thanks. Keep coming. Keep the dogs coming. Alex says, hey, not a requirement to run, but after being elected. I don't think that will make a huge difference, Alex. The only reason I say that is if you are an elected person, I don't think that is a part of the requirement for being a member of the board. So I don't think that difference is going to make a distinction to a judge or to DCA. Al says, interesting, Board of Trustee would not move forward until code was signed. So can I withdraw my agreement under duress? So I love you, Al. You're the man. So you can withdraw, and this is not legal advice. You can withdraw to the extent that that is effective from an agreement that you've signed, right? So you go out there and say, hey, I withdraw my agreement. I don't agree. If you learn things during your board tenure that were to be kept confidential, they must be confidential, regardless if you say, I withdraw my agreement, nanny poo poo. You are still bound. So, but I do appreciate it, Al. Will says, Fran, can you provide an update on the trustee lawsuit in South Jersey in which the trustee won a very large award? So that was the Ocean Towers case, I believe you're talking about. It really wasn't a very large award. It was an attorney fee shifting case with respect to indemnification for wrongful removal of a board member. And what had happened there was, Bill, was that the association's insurance carrier wound up having to pay the tab, I think, for both sides of that lawsuit. And that's what really was impacted in that case. The indemnification provision was extended. I have not looked at the more recent appeals decisions on that. I think the ultimate award was trimmed down somewhat, but I do not believe the decision on indemnification was reversed. I think it was upheld. Does confidentially extend to past board members time on the board? Yes, Alba, it does. Thanks. That's a great question, Alba. If you're off the board, it doesn't mean, hey, I lost my election, so this is what I'm going to do. I'm going to run out and tell everyone why Mrs. Jones has an assigned handicap parking spot. No, you can't do that. And you may get sued individually because someone would construe that as a purposeful, wrongful act. And you may not be indemnified by your D&O insurance, right? So if I, for example, find out that Mrs. Jones has MS and that's why she has a designated handicap spot, even though sometimes she walks quite fine, and you run out there and run around and do all kinds of crazy stuff and say, Mrs. Jones, I want to tell you, I don't like her anyway. She has a problem and this is what it is. And I learned it when I was on the board. You still are exposing yourself to a claim by the association and also a claim by Mrs. Jones. Can the board censor residents for producing their own newsletter? Can the board censor? Colleen, I don't know, but censor is like an old-fashioned word I haven't seen in a while, Colleen. So I'll try to interpret that. So what I've seen most, Colleen, in terms of residents producing their own newsletter is obviously it's still America, right? So board members, non-members, other people, as long as it's not confidential information, can be spoken about, and it can be put in a newsletter or blog or a web page, those types of things. Where things get really funky is we'll call it the alternative newsletter or the alternative web page, gives the people the impression that it's an association web page. So it's Tall Tree Association, right? And the association's website is talltreeassociation.com. And somebody else puts up the real Tall Tree Association.com and has all their kinds of stuff out there. And it confuses the public. And you may have heard me talk about this before. The seminal case law on this type of stuff, at least with respect to websites, comes from a group, believe it or not, called Jews for Jesus, JewsForJesus.com, right? So JewsForJesus.com was some type of organization. But it had religious things going on, and another group had JewsForJesus.com or a similar website that was directing the people who went there back to what they felt was their proper religion or religious beliefs or whatever it was. I didn't get into the religious part of it, but and the court said, no, you can't go out there and fool around and confuse people, right? You can't confuse people. So that's the issue. The competing newsletters, put aside confidentiality a moment, put aside the First Amendment for a moment. I have seen competing newsletters a number of times over the years, and sometimes they are used in the way of the National Enquirer, that they are used to sow dissension throughout the community and sensationalism, right? Which is not a good thing. Now, everyone is entitled to their First Amendment rights, but sometimes common sense goes out the window. So I would encourage anyone who has a separate newsletter or a separate website or what have you, just to keep that in mind. I had an association in South Jersey where a very assertive person had an alternative newsletter, and a lot of things that were in there were really, in my opinion, aimed at, I'll be nice and I'll call it muckraking, as opposed to rational dissent, right? Or alternative opinions or alternative views, which are personal. It was totally fine. It went so far as this person was selling advertising in his alternative newsletter. And, the muckraking kind of, I think, helped his circulation, but I don't think it helped the association as a whole. Let me know if I'm being too pedantic. Can the board censor residents? So I think the answer to that is no. So Al says, thanks, Fran. Do you understand the confidentiality part? I think I do understand the confidentiality part. Things that are confidential should be kept confidential. Should an association post executive session minutes? No, association should not post executive session minutes under the new regs. In fact, in theory, there are no executive session decisions, right? You do, however, have to produce executive session minutes if they, for example, are subpoenaed. The issue with executive session minutes is, though, they are often subject to redaction. And that can be a costly process, because usually what happens is when executive session minutes are subpoenaed, where there's notice to produce by another party, somebody in our office has to go through them and actually black out the various items that are subject to attorney-client privilege or the personnel exception or what have you. So you got to be really careful about executive session minutes. Fran, what is your thoughts on ex-board members turning over documents, emails, confidential after leaving the board? I think Rich is probably referencing there, should they be returned to the association? I'm a fan of that, Rich. I think people who are departing the board, the best practice would be that they turn all that confidential information back over to the association. How often do I see that happen? Never, right? It would be a good practice. I don't see it. It's even sad that I have seen a number of cases, especially in small associations, where there's a board president or a board treasurer, especially in self-managed associations, where all the stuff is kept by that person, and that person either dies or moves to Florida or somewhere else, and it all goes in the garbage, and this, I've actually had this case. I asked the surviving spouse, hey, where is Harry's 3 bankers boxes? And she goes, yeah, they are gone as of last week, right? And you're left with a problem. So there's a confidentiality aspect of that. There's also an issue of institutional knowledge. So departing board members, whether they depart voluntarily or by act of God, so to speak, you would want to get that information back in a perfect world.
Hey, Fran.
Yeah.
Just a comment on the last issue about the executive session meeting minutes. So just so everybody knows, not executive session, but your regular open board meeting minutes have to be made available in draft format before they're officially approved by the board at the next meeting. And that comes from the DCA, newer regulations from 2020. They make it clear that we just have to make that available to the members within a reasonable amount of time after the meeting.
Right. Okay. Thanks, Mike. That's great. Yep. So Colleen says versus punish. Yeah, Colleen. No, I don't think people are looking to punish anybody. As you know, I'm not looking to punish anybody. And I'm a big First Amendment free speech person as well, and transparency. Eileen's telling me, Fran, it's 4:50. You have a later appointment. You got to get off the call. Thanks, Eileen. So we got one more question. What are your thoughts of a board member who continues to hang out at the community manager's office, yet being told not to do same? So it's a problem, Al. That's a really good question. I believe that the board should vote and direct that person, whoever it may be, and put it in the minutes that they should only be in the manager's office during a certain period of time. We see many associations where the manager's day is spent with a board member, oftentimes it's the board president, right in front of their desk, right? And the board member wants to micromanage the manager. And then I get a phone call eventually and saying, and the board member goes, hey, Fran, you know, this manager is awful. She never gets anything done. And I call the manager, I go, this is weird. Kathy just called me and say, you don't get anything done. And she goes, yeah, because Kathy's in my face all day long. The other thing about that is there are some associations, especially with portfolio managers, where they have very limited hours where the manager is on site. And those limited hours when the manager is on site, they have unlimited office hours. So the whole time, limited time they're on site, people are coming and going, residents coming and going, residents coming and going. And they go, hey, Mary Ann's not getting her work done. And she's only here 10 hours a week or whatever as a portfolio manager. And I go, why not? And they go, well, because people are in her office, in and out, in and out, in and out. I go, you got to set office hours, visiting hours, because she's only being paid for 10 hours a week, right? Under the management contract. Only a small fraction of that should be visiting hours, right? So you have to manage your manager to some extent when it comes to her time. You can't unleash the whole membership on the manager and then say, do your work, because she can't do both things or he can't do both things. Beth Duffy says, does that really happen? Let's see. I know you were being sarcastic, Beth. I know. So that's it for me for this week. I hope everyone's doing well. Any other questions, please hold them for next week. I got to jump off the call, but it's great for seeing everyone. And we'll see each other in October, and things should cool off a little bit by then. Thanks again, everyone, for coming. As you know, we really appreciate you attending every month. Thanks again. Great seeing everybody.